Hey everybody, welcome back to Guns and Gadgets, your premier source for Second Amendment news. I wanted to take a minute to tell you guys and gals about another Second Amendment based case that the Supreme Court has decided it wants to take up. The original case happened way back in 2013, and the way it went down, I'll just give you a quick rundown on this. The Rodriguez family, Edward and Lori, unfortunately Edward was removed from the home for a mental health screening. He had some issues, and when he was removed from the house, the San Jose, California Police Department, the officer who was there told Lori, "I now have the authority vested in me by the king of the land to seize all the firearms in the home." Now, beyond obvious reasons why the guy in the uniform with a badge shouldn't be able to seize somebody's freedom and tools because somebody was ill, that's a different story, okay? That should enrage people all on a different level. We're focused on what happened right now, and this is what the Supreme Court's looking at. So Lori's and her husband's guns were locked away in a safe according to, in accordance to California law. The cops seized Lori's guns as well. Even though she didn't do anything wrong, had all the licenses she needs, the cop took hers because he's the king. Now, it needs to be said that there were no warrants, there were no criminal charges, nor were there any mental health holds on Lori, just her husband needed some help. Now, fast forward 7 years, Lori still doesn't have her firearm, but they have told her that she's free to buy more. Now, the police officer in question, his name is Stephen Valentine, and he took 12 firearms from the home, like I said. Now, he told Lori that the seizure was mandatory under California law, but that law required all firearms from an individual who was placed into a mental health facility to be seized. But she wasn't placed into one. Now, of the 12 firearms they took, 11 were her husband's, but one of them was hers. Now, of course, she objected on the scene, and that firearm was even registered to her to prove that it was hers. But the King officer, Valentine, didn't want any part of that. Now, it gets worse if your name is Rodriguez in this case, because a month later, the city of San Diego did something very odd. They filed a request to keep the guns because, get this, Edward Rodriguez and others would be placed in harm's way if his firearms were returned to him. Now, while Edward didn't contest that, Lori did, and what she said was the following. The court had no power to interfere with her Second Amendment to keep and bear arms because even if Edward was prohibited from possessing and owning guns, now because of the mental health issue in California, she was not prohibited. In support, she emphasized that she had obtained a notice of eligibility to own and possess guns from the California DOJ Bureau of Firearms, that's the Department of Justice in California. Lori further represented to the court that if returned, the guns would be secured in her gun safe, and that she had changed the combination code so that Edward would not have access to them. Therefore, she contended the return of the firearms would not place Edward or anyone else in harm's way. And the Superior Court judge, it's California, disagreed with her. And the judge said this, it's not appropriate to return any firearms to the Rodriguez residence, though the judge did point out that Lori Rodriguez was free to purchase firearms on her own. The judge just wasn't going to give back the ones that were illegally confiscated by the Gestapo. Rodriguez ended up registering all 12 of those firearms in her name because they were her husband's, transferred the property to her, and she is now the registered owner of those. She again attempted to get those firearms returned from the city of San Diego, and they told her, sorry, we don't believe in the Second Amendment, you're not getting your guns back. And that is when she filed a federal lawsuit. Now, this lawsuit went up to the Ninth Circuit Court of Appeals. Many people know how fun that place is. It's the most overturned circuit in all of the land. And the Ninth Circuit upheld the Superior Court's decision and decided they weren't going to let a constitutional abiding citizen have her constitutionally recognized and protected property because she did nothing wrong, wasn't a criminal, wasn't prohibited federally or locally from obtaining those. They just didn't want her to have them. This time at the Ninth Circuit, not only did Rodriguez say her Second Amendment was violated, as was her Fourth Amendment, the protection against illegal search and seizure. But the court said that the warrantless seizure of her property wasn't a violation. Can you imagine that? And here's what the court says, an excerpt from the case. The seizure of the firearms did affect a serious private interest in personal property kept in the home. On the other hand, the public interest at stake here was also very significant. San Jose police officers had previously been to the home on prior occasions because Edward was acting erratically. And on the day in question, Edward was ranting about the CIA, the Army, and other people watching him. He also mentioned shooting up schools, specifically referencing guns in the safe. Edward's threats may not have been as explicit as the threats made in Mora, which is another case they had out there, but a reasonable officer would have been deeply concerned by the prospect that Edward might have had access to a firearm in the near future. So that officer decided that he was going to strip everybody in the house of their rights just because, you know, maybe safety. Consequently, there was a substantial public safety interest in ensuring that the guns would not be available to Edward should he return from the hospital. With significant private and public interests present on both sides, the urgency of the public safety interest is the key consideration when deciding whether the seizure here was reasonable. Not the fact that your constitutional rights are being violated, it's just our public safety. Ninth Circuit also ended with saying, "We believe that on this record, the urgency of the situation justified the seizure of the firearms," and they couldn't have been more incorrect. So it was appealed to the United States Supreme Court. California Gun Rights and the Second Amendment Foundation are involved in this case, and just the other day, the United States Supreme Court issued a writ of certiorari. They also sent a message to the city attorney in San Diego and demanded an answer on this case within 30 days. What's interesting here, there are 3 questions proposed in this case right now to SCOTUS, and those questions are the following. Number 1, whether the Fourth Amendment allows an exemption to its warrant requirement for so-called community caretaking, where an alleged danger to the community has been resolved, and the premises to be searched and the items to be seized do not contain or pose an immediate threat, making it impossible to obtain a timely warrant. Now, for those of you who are not familiar with the Second Amendment or the Constitution, aren't familiar with constitutional law, don't work in the field where you operate within the Constitution, let me try to put it in layman's terms for you. If government is in your home because of an immediate threat, meaning you're threatening to murder somebody, kill somebody, etc., they're there answering that call. If they find a firearm while the incident's going on, they can seize that firearm. Now, Mr. Rodriguez, who at the time was having a mental health issue, was taken out of the house, okay? When he was taken out of the house, any threat, whether it was real or perceived, was gone. Left the calm wife there, and they violated her Second Amendment. They seized those weapons off of public safety interest, but the threat was already gone in the ambulance on the way to the hospital. The threat no longer exists, which is what this question is. Is there an exemption to the warrant requirement, is what they're asking. And I can tell you, there isn't. Unless the Supreme Court creates one in this case, the police are dead wrong on this one. Now, the second question to be answered has to do with California law versus federal law. And question number 3 is whether the court should exercise its supervisory power to review the improper circumvention of the Second Amendment protections in the Ninth Circuit, or at a minimum, hold this case until the New York State Rifle and Pistol Association versus the City of New York is heard. And we know that they're holding that, they're waiting for that case, or we're waiting for that case, and we should hear something in a couple months here. I think the first week of June was their original target. Whether the whole farce of COVID stuff stops that, we'll see, or delays it. I mean, it's not going to stop it. But that case could be very, very important, not only for New York City, but for many cases around the nation where municipalities think they can just own you and stop your Second Amendment. Now, like I said, the Supreme Court has given the city of San Jose 30 days to answer those 3 questions, or what their opinions are on those 3 questions. Now, of course, the city will probably just use the same rebuttals it did when it was at the Court of Appeals. That's typical of lawsuits like this. So we will see what happens. Now, what everybody should be aware of is that the amount of cases that the Supreme Court is actively considering related to the right to keep and bear arms is growing. And it takes just 4 justices to agree to hear a case. Now, everybody out there that knows anything related to the Supreme Court is saying that the court's not going to really do much with any of these other cases until the New York State Rifle and Pistol Association versus the City of New York case is ruled on. Why do you say? Because depending on the ruling of that case, it will have an effect on every other case waiting before the court related to the Second Amendment and the right to keep and bear arms. Now, it also should be noted that even though the court issued a writ of certiorari, does not mean they're going to hear the case. It means they're interested in looking at it, and then they're going to have to conference and decide if they're going to take the case up or not. But again, it could be determined to be moot based off the ruling of the New York State Rifle and Pistol Association case. So if you want to know more about that and what happens with this case and the ruling we're waiting on, you should subscribe to Guns and Gadgets. Pretty easy, right underneath me. Hit that button that says subscribe, and you'll know, because you'll be part of this growing freedom family. The Guns and Gadgets channel is where you will find Second Amendment news, whether it's good, bad, ugly, or indifferent, no matter where it's happening in the nation. And I can tell you that with the growing amount of Second Amendment cases in conference right now in the Supreme Court, we could be poised for another landmark decision. So stay tuned to the channel, subscribe if you haven't, because you don't want to miss it. And until we see each other again, be safe, stay vigilant, carry a weapon, and I hope you have a fantastic day.